Hi, I'm back, and today I'm going to talk about costs in financial remedy cases. As you know, I'm from Family Law Cafe, and I do these chats to give people an idea of what the law is in family law. Some things you can do yourself. I wouldn't really go and deal with costs yourself because it's quite a complex area. I suppose the first thing to think about is what does financial remedy actually mean? It used to be called ancillary relief, financial remedy, and the idea of that term is that we're talking about the finances that are dealt with when you get divorced. Now, probably a lot of people think it's all changed, but the only thing that's changed in divorce is how you get the divorce. So the financial remedy is how the court would divide the assets if you couldn't agree. Obviously, in lots of cases, people agree how to split things. There might be a family home, usually is. There might be savings, pensions, policies, chattel such as boats or cars or guns or whatever you have, legitimate guns, of course. There might be all sorts of things that you have between you as a family, as a couple. And if you cannot resolve how to divide those, then there would be what's called a financial remedy application by one of you, and the court would help you decide. Many cases get decided in court-led mediations called financial dispute resolution appointments, and some cases even go as far as a final hearing. So I think it's really important that you know how the cost regime works in this area, because you might have a letter early or during the proceedings that scares you, saying, if you raise this, we're going to rely on this in an argument on costs and this letter will be produced. Or you might be saying to your lawyer, how come they're raising all these issues that they're just really not important? My costs are going up and up and up. Is there a way I can protect myself? What can I do about it? So I think if you have a broad idea of the area, it's going to help inform you to make decisions. So I'm not saying you're going to remember all of this. So I'm just going to give some broad outlines of how it all works. And I want to say that this area, I think, it's just, the people that write these rules, they just don't write them very well. I think it's just all over the place. That's my personal opinion. Happy to put it out there. Have parliamentary Treasury Council or whoever who write this stuff, and full of double negatives and, this applies, savour this, etc. And you have to look all over the place to understand it. It really is not easy. And I think the other thing that isn't easy is to sort of cap it all. There's sort of discretion upon discretion upon discretion. So the certainty element is, it's not certain, and lots of different case law and lots of different arguments that can be raised. So I'm going to try and give you some broad principles, because I hope that will help you. So I've said what financial remedy is, and I'll be going back to that, because within these rules, some things are included as financial remedy and some aren't. So let's just start this from the top and say that it all comes from the Senior Courts Act, Courts Act 1981, Section 51. Says, provided, subject to the rules of court, costs are at the discretion of the court in family proceedings. So there you go, start with the discretion. And then the rules are actually contained within the Family Procedure Rules 2010, and they're at Part 28. So that's where they are. And there is also a practice direction at 28A, and that's where you're going to find all this information. So if you want to go away and look at it, be my guest. I don't think you'll enjoy it very much, but people like me enjoy it, and lawyers enjoy it. But that's where you're going to find the rules. But those rules are also, the rules about costs are also contained in the civil procedure rules, because for some parts of the cost rules you have to go back, and there are some parts of the civil procedure rules that apply to family proceedings. And so when you go back into the civil procedure rules, you'll find that there are parts 44, 45, 46 and 47, and some of those apply, and then there's a section which says, but the main thing that doesn't apply about civil costs as compared to family proceedings is this, that in civil proceedings, costs follow the event. Winner is usually gets their costs. That's a start point. Whereas in family proceedings, the rule is no order as to cost. So each party bears its own cost. That's the start point. So that's the big difference. So as a start point is each side bears its own costs, then it's really important to know, you go back to section 28, and that's at section 28.3 defines what are family proceedings and financial proceedings rather, my apologies. And then there's a definition, and that's where you get all the referrals to different parts. But if you can think about it in this way, it's the interim applications are not subject to this rule, so you can get a costs order in interim applications, you can get a costs order in enforcement applications, you can get a costs order in if you're applying for the other side to pay your legal costs. Those are the big areas. And to also say that applications under Schedule 1 of the Children Act, if you're applying for financial remedy for your child, if you're not married, that's a different regime. And if you're not married and it's an application under Trust of Land and Appointment of Trustees Act, that's not covered either. So the rule of no order for costs applies to financial remedy, and so that would be the usual case where you've litigated, you've come to the end of it, you've gone to a final hearing, and the court's made an order. This person has a lump sum, this person has this pension, the house is sold, or whatever orders they are made. And so the court will make no order as to costs. So each side will bear its own costs. Except then you look at the rules there, and if one party can argue that there has been conduct by the other party that justifies a different order, then they can raise an argument as to costs. Now, conduct will be, it can be a range of things, and conduct can be not complying with disclosure would be a really big one. So if there was non-disclosure or there was late disclosure, so that had racked up the costs, increased the costs, that would be conduct. Usually, that would be your argument. If a party had raised an issue or pursued an issue that just wasn't really justified, if they had said, oh, you have another property, I know you have a property in Ireland, and everyone had spent lots of money trying to find this property and there wasn't a property, then you could see that would be an argument for saying, well, my costs have been increased and therefore they should pay my costs on that element. It could be another really big one, and one that's been just changed a couple of years ago, and almost rides a coach and horses through this, is this one. It's a big one. If a party has failed to negotiate reasonably, and what they've brought back in is if you make an offer to settle, say 18 months before the final hearing, you'd put in an open offer where you'd said, I'm happy for, let's say, the wife to have, for the house to be sold and the wife to have 80% of the equity of that for rehousing. I'm happy with 20% and I want to keep my pension. Say that was your offer, just for the sake of argument. And at the final hearing, the judge ordered something that was as good as that or better. Then you could say, well, look, I was completely helpful. I made a very sensible and generous offer 18 months ago. I've had all of these costs since then. Wife wanted 100% of the equity of the house. I always said that was unreasonable. She hasn't got that. And so I now want my costs. And that's been introduced possibly because the courts wanted to make sure people really did negotiate and negotiated fairly, but it's only for open offers. So if that offer had been made with a heading on it saying without prejudice or without prejudice subject to costs, which is an old phrase that just shouldn't even be used now. So if it had been a hidden offer without prejudice or without prejudice subject to costs, then you couldn't bring that in. You couldn't argue and say, oh, we didn't, we wouldn't need to have this litigation. It has to be an open offer, i.e. an open offer is an offer that anybody can see, that can be shown to the judge at the final hearing. And it's a really big change that's been made in a couple of years ago. And even if the wife in that case said, by making my costs, his extra costs have been £50,000 since that time, and the judge could still say, because the husband in that case made a reasonable offer 18 months ago, it's all gone to hearing, it wasn't reasonable for you to pursue getting 100% of the equity of the house, then I'm now going to order that you pay that further £50,000 of costs. And even in a needs case, there's an authority on this, that's an order that could be made. So it's really important to make sensible offers in a case. It's really, the court considers it very, very important that you do so, even to the extent of saying it's conduct if you don't accept a reasonable offer. And if you think about it, that's a bit of a stretch to conduct, because conduct usually means behaving unreasonably. This may be very fast. I'm not sure if it's all sinking in, but the big issues are generally, unless it's an interim order, interim being pending a final order, or an order after the final order being an enforcement order, generally it's no order as to cost, so you bear your own costs. And that means that I think the reason, I'm going to give you the reason behind it, because about 20 years ago, there were different costs rules, and the courts just felt it was a simpler regime to say each side bore their own costs, save in cases of conduct. And bringing in the idea, or the concept that an open offer, if you put in an open offer and you do as well as or better than that at a final hearing, is something that's been introduced in the last couple of years as being part of conduct. And I think it's just to try and make people settle more cases, basically, and not have so much litigation. Other things to tell you about costs is that it's right that you know that there is a protocol in this area of good practice. And it's good practice not to pursue points that are disproportionate, that are not going to really affect the outcome. So if you are, or if you're asking oppressive amount of questions, so for example, there might be a pre-litigation exchange of disclosure, which is a good idea. But if you're asking for 5 years of bank statements or this kind of thing, where there isn't really a need for that, just fishing, then a court would consider that could be conduct that was just pushing up the costs. And so, and because there's a protocol saying you shouldn't be asking oppressive amounts of questions, you shouldn't be pursuing issues that are not really relevant or only peripherally relevant, then those could be arguments that could be used in a costs argument in financial remedy. I'm going to run through the court's requirements about costs. So if you're going to a hearing, a first appointment or financial dispute resolution appointment, you need to file your cost schedule in advance by way of a Form H. and you need to say exactly what you've spent just on the financial remedy side. And you also need to say what you anticipate spending. And the reason that you have to file those forms, and it's a rule of court, have to be filed at least 24 hours in advance, is that the courts are checking are the costs proportionate. And you can be in a situation in which your costs could be, let's say, 20,000, the other side's are 50,000, and you can argue then that their costs are excessive. That could form an argument at final hearing where you say their costs are so much more than my costs and they're unreasonable, and I want the court to take that into account and say that they shouldn't be allowed to claim that as a debt in the final analysis, that they've overspent on their costs. And that form you have to say that it's true, and you obviously can't exaggerate your costs, so you're giving a statement of truth that those are your true costs, the costs that are payable to your solicitor or direct access barrister. And at final hearing, 14 days in advance, you've got to put in your statement of costs, your Form H1, which is similar, but it's setting out all the costs that you have incurred, and the court will look at those. And in the vast majority of cases, the court will take into account any legal costs you've still got to pay as part of your overall financial position, because they're always looking at the end, the final order to be a fair order. Let's tell you about how you claim your costs. So if you are saying that you are claiming your costs, then you need to set that out either in a letter, in correspondence, or in your skeleton argument before a hearing. And you need to serve a schedule of your costs. And you use, it's a civil procedure form, it's N240. I think it's 240 or 280, I can't remember. I think it's 240. And I find this form completely inappropriate for family because it has lots of parts of it that are just appropriate for civil proceedings, not family proceedings. I don't know why they don't make one for family proceedings, they don't. And it's completely inappropriate when you've used a public access barrister, which you've been able to use now for almost going on, I don't know, is it 10 years or 8 years or so. They just haven't updated the form, don't know why. But you have to serve that form 24 hours in advance if you're seeking a summary assessment. And a summary assessment means the judge decides at the time. In terms of how a court will decide on whether the principles of making a costs order, the court will have regard to a number of factors, and they're set out in Rule 28, subsection 7. And these are the factors. Any failure by a party to comply with the rules, any order of the court, or any practice direction. So means what it says. If you haven't done something that you were supposed to do, then that could found an application for costs. And any open offer to settle made by a party, I was talking about that just now. So if a party had made an open offer and you disregarded that and ploughed on, then that's something the court can look at when deciding on costs. The next is whether it was reasonable for a party to raise, pursue or contest a particular allegation or issue. So have you raised an issue that really wasn't reasonable to pursue? It's not saying that because you raised it and you weren't successful, there will be a costs order. It's looking at the court's discretion to say whether that was conduct, whether it was reasonable to raise, pursue or contest a particular allegation or issue. Any other aspect of the party's conduct in relation to proceedings which the court considers relevant, such as a catch-all, and then lastly, the financial effect on the parties of any costs order. So I think it's important to remember that, you know, just going back to where we started, that costs are discretionary, and there are all of these arguments about costs, but often a judge just going to sit back and say, you know, is it fair? Is it fair to make this order? There's all of those arguments can be put. This person pursued this; they shouldn't have. I'm out of pocket because of this. But the court maintains a wide discretion, and there will be very different orders as to costs made by judges because of the discretion they have, and it's completely unappealable, frankly, because as a judge will say, well, I'm exercising my discretion in this way, and they can pull out different factors. It would only be if they suggested a fact that was completely, not within any of those areas. And the courts can also, they don't have to award all of the costs. They might award a proportion of the costs. So they might say, well, 50% of the costs, or they might award costs from a certain time or to a certain time. So there are different, they don't have to award all of the costs, or they might look at the cost schedule and a summary cost schedule and say, and they'll go through it and say, well, the solicitor shouldn't have spent 4 hours doing this, I'm going to allow 2 hours. We didn't need to have both solicitor and counsel at the final hearing, so I'm only going to allow for one of them. And so they would go through their summary assessment. Whilst they might order costs, they might not order all of them. And then another thing a judge might do is say, if it was very complex, rather than looking at the costs on the cost schedule, would say, I'm going to order costs, and those costs can be assessed if not agreed. And that phrase means, if assessed if not agreed, means that either the parties will agree the amount of costs to be paid, i.e. One party's established there will be a cost order, either they will agree it between them, or the party claiming the cost, the solicitor has to send in the file to the court, the judge goes all through it, they have to do a really lengthy explanation of all the costs that have been incurred, and then a court would assess it, and often they will reduce the amount that's claimed, just how it is. It's kind of rule of thumb, they generally reduce by about a third. I hope it's not too overwhelming. There's a lot to it, but I think, big areas. Costs are discretionary. In family proceedings, apart from interim enforcement, costs are met by each party. You bear your own costs, save unless there has been conduct by the other party. And I've run through the examples of conduct and the usual ones that you would think of, not revealing assets and increasing costs, pursuing unmeritorious arguments, not complying with court directions. They're all obvious. But as I say, this new one where a party has made an open offer and then they've done better at the hearing. It's a really tricky area, and it's really worth digging in, thinking of your particular case and thinking, well, where are all the arguments? So a party might have put in an open offer, but you still might have done better than that, or other things have happened since then, and it's not as strong as they think it is. And in terms of even if a cost order is made against you, to argue and say it should only be from this date, or it should only be a percentage, or look at the overall financial position, and there's an unfairness if you make an order for costs. So I think we can I could probably just chat on with costs. It's not I don't think that the rules are particularly clearly written. I was in a case about 6 weeks ago, and the other side were asking for costs, and I just said absolutely no way, and it's completely wrong, and they were completely wrong, and the judge was confused, and actually asked me what did interim mean, which I found a little bit difficult to answer. It means pending, doesn't it? Interim, and they were trying to say this was an enforcement order, and it clearly wasn't. And so I think you have to be really on your toes with this, because people, they get confused themselves, and judges can get confused. And you have to be quite fast with it, because in my view, a judge, sort of, if it's at the end of proceedings, sometimes the last thing they want to deal with is costs, and you've got to be really clear about what you're saying or what you're arguing against it really, really fast, and just get some really basic points in. I think fairness is a big one, and if it just doesn't seem right, then they don't tend to make these orders. Whereas if you've been in proceedings where, I don't know, I got a costs order in a financial remedy case in which they just had been incredibly difficult all the way through, and justifiably we got our full costs at the end of it, and even then, they dragged it out, and we had to go to an assessment, and so it can take time and be quite tedious, but really, really important to know what the costs orders are in broad terms, so that you can be aware of that and make your decisions as you go along. Okay, on Wednesday, I'm going to have a chat about costs in children cases, because that does pop up. It's a completely different regime, and we can talk about that then. Anyone got any exciting questions about this, then please raise them here. I can't see any on the comments, but I don't know if I've missed them. I can see some various comments. I hope it's been useful, and you can always listen. We'll post this up again, and you can listen on the replay if it doesn't make sense the first time. Bye-bye. Have a good Sunday.